Picking back up with the Solicitor General, he or she has a number of staffers, and they represent the executive branch when it comes to the federal court systems. So what he and his staff, or she and her staff, would invoke in the justice system is the voice of the president. This position obviously is a very prestigious position, and typically the persons filling this position have a great deal of jurisprudence, juris experience, and typically are very influential persons. Now, most courts, if you guys remember when we covered the 10th Amendment earlier on in the semester, the separation between the state and national governments, most courts and most trials and most cases actually happen in state courts. And within the state courts, you have a similar structure where each state has its own Supreme Court as well as district courts. So for us, each county has its own courthouse, and each county system is part of the state system, the state judicial system. It's important to also understand that most cases are probably civil cases, and civil cases, that refers to issues about money, divorce, child custody, and there are also a number of criminal cases, cases which stem from misdemeanors all the way up to felonies. And felonies, that typically has to do with the severity of the case. And in some cases, there are situations where you have a person's life or their livelihood can certainly be at stake. Very similar to the federal courts, the appellate system works in our state courts in Florida. We have district courts, one of the larger ones in at or around the Duval County area, very large appellate system there. Typically, your appellate courts and your district courts are going to be centered around population, large clusters of population. So it's imperative to understand that there's a very distinct system of state courts and a very distinct system of federal courts. One of the first things we would want to look at, and state laws in many cases vary from state to state. Their Supreme Courts for their states are very much like our federal Supreme Court, in that they also get to hear cases as they choose. One good example, Georgia versus McCluskey, 1971. There was a gentleman named Mr. McCluskey who was convicted in district court in Georgia for murder. He'd murdered a police officer. And the situation surrounding McCluskey's case was he was holding up a department store, I believe it was a Woolworth at the time, and on the way out, as he was leaving the department store, he shot and killed a police officer. Now, Mr. McCluskey's appeal was that his murder of the police officer was actually self-defense, that the police officer was going to shoot him, and so he only shot in self-defense. This went up through the appellate system, and the Supreme Court of the state of Georgia ruled in favor of the state's conviction and upheld the condemnation of Mr. McCluskey. Again, typically, even with the states, the Supreme Courts are seeking to impact public policy through their rulings. One of the most interesting things that the courts have, particularly the federal courts, the Supreme Court, is a tool called judicial review. So if you look back in your slides and you look back in your textbook, we can look at the case of Marbury versus Madison, 1803. And what you have in that case is Mr. Adams, as he was leaving office, he made a number of what we call midnight appointments, in which he made crazy appointments to try to thwart the presidency of Thomas Jefferson. Some of those cases were done with field expediency. One of the cases in which William Marbury was appointed as the Justice of the Peace for the District of Columbia. Another appointment came in, James Madison, as a Secretary of State, he actually, under Thomas Jefferson, he actually refused to acknowledge the appointment of William Marbury. William Marbury, in turn, filed suit, Marbury versus Madison of 1803. And the courts at the time supported Mr. Madison. And afterwards, what we got out of the big takeaway you want to walk away from Marbury versus Madison with is judicial review. And that is the option of the federal courts, of the Supreme Court, to go back and review the constitutionality of a law or an action in which the government has taken. So with the Supreme Court, their coverage, again, media coverage is rampant on other parts of our American national government, but not so much with the Supreme Court. They do, again, get to enjoy relative lives of secrecy and majesty. And during their deliberations, there's no media coverage. So what these guys, and you're talking about a group of 9 very seasoned individuals. Supreme Court justices have also been known to recuse themselves in certain cases. Sometimes it might be where a Supreme Court justice was a federal judge actually in a particular case, and he or she may choose to recuse himself or herself from the case. Typically they don't have to, but that is another practice that oftentimes they will invoke just to ensure the stability of the courts. I think it's also imperative when we look back at the structure of courts, and we understand the appellate process and also the funding process. So, the courts, the Supreme Court, they can't invoke action on parts of the legislative branch. They can hopefully encourage them to pass laws that benefit the American people. And they also hope to encourage the president. The Supreme Court typically may get involved in some international cases, but typically only if it involves human rights issues. Whereas we've covered in the past, you see in certain time periods and in certain eras, you almost see Congress competing against the presidency, or the presidency competing against Congress. The Supreme Court, very much not that case. The Supreme Court, they almost function as referees, but as a refereeing system or a rules-following system between the other two branches.